Hello, Hector Quiroga here with the Quiroga Law Office, and this is a presentation that I did in conjunction with Catholic Charities with Greg Cunningham. This presentation was done at the end of 2013 and March of 2014 to the Spokane County Bar Association in Washington and subsequently in the Idaho Cunningham County Bar Association in March. We united forces to give some clarity and perhaps open the discussion with criminal law attorneys in both states to help immigrants and who are having uh, implications of crimes negatively affect their immigration status. The main points of the presentation that we hope to achieve, and we hope we did, are what types of criminal activity can have an impact on immigration, at what point does crime impact immigration, uh, give a few tips for defense attorneys to mitigate that impact, what immigration remedies are available for crimes, for example, waivers, and other type of remedies, for example, U visas, T visas, and VAWA. We kind of go more in detail later on as to what those things mean. We started with what terms are kind of sort of impregnated within immigration law, and they are kind of counterintuitive, at least I thought so. Immigrant is defined under the law as any individual who comes to the United States with the intent to stay. So, a spousal visa, for example, that's an immigrant visa because the person seeks to come in, marry, and then stay here as a permanent resident. Non-immigrants would be those individuals who are coming to the United States and seek to return to their country of origin, for example, a tourist. Um, and so those distinctions will be important later on the applicability of immigration statutes. Lawful permanent resident, legal resident, resident alien, green card holder. These are terms that are interchangeable. It's just a person who has been admitted as a permanent resident and will have or vested all of the uh, rights and responsibilities and duties of a citizen, with a few exceptions, of course. We'll go those in detail. We might look at them. Adjustment of status, consular processing. Adjustment of status is the process in which somebody becomes a legal permanent resident or a green card holder. They can do it here in the United States. They can also do it through consular processing. And consular processing is basically the same process, but it happens through an embassy or a consulate abroad, usually on the country of origin of the immigrant seeking to come to the United States. Naturalization, that's the process in which an individual becomes a United States citizen. There are two ways to be a United States citizen, and one is by birth and the other one is by naturalization. Uh, Inadmissibility or deportability. Well, inadmissibility is when you're not admitted, and deportability is when we want you out. Uh, these are, believe it or not, kind of the main points that we're gonna see, and kind of where a lot of defense counsel needs sort of help because these are the 2 points that can really greatly impact an immigrant when they are being held or being charged with a crime. I like to think about this as a party. The United States is a party, it's a fancy party we like to go to. And to go to a fancy party, we have a cover charge, we also have some dress code, and we have to be properly admitted and check out that our cover is paid and that we meet the dress code to be able to come in. And so that process to come to the party, you have to have a visa, a permission to knock on the door, to even present your documents to the bouncer, whether or not you have the cover and whether or not you are dressed appropriately. If you are admitted, then once you're inside the party and you do something that is silly, you commit a crime, you do something that is not within the rules of the party, then you can be found deportable. This becomes somewhat complex, and we're going to see later on, because there are certain things, certain crimes, certain concepts that will render an individual inadmissible but not deportable. there are some things that render an individual deportable but not admissible, and there are certain things that render an individual both inadmissible, deportable. So it depends and is very fact specific as to your client as to whether or not they have been admitted, whether or not they can be deportable, and we're gonna explain why here in a minute. We talk about VAWA, U visas, T visas, VAWA, Violence Against Women Act. We'll go a little bit in details towards the end as to this. U visa is for victims of crimes. If somebody is a victim of crime and they help prosecute, they could get a special immigration visa in which they might be able to stay in the country, and this is important for certain defendants that can help in prosecution. T visas, the same as a U visa, but really just specific for human trafficking, when human trafficking is the issue. Immigration Nationality Act, that's the INA or Title 8, that's where all of our immigration code comes from the federal statutes on Title 8. Federal agencies that we deal with the United States Department of Homeland Security, and under that umbrella we have USCIS, Citizenship and Immigration Services. It used to be called the INS, but it is the USCIS now. Immigration and Customs Enforcement, which is US ICE, and Customs and Border Protection. Those last two are kind of more of the law enforcement arm of the Department of Homeland Security when it comes to immigration. USCIS is more of the administrative branch that processes applications. And then we have the Department of State, which is the department that is in charge of all the consulates and all of the embassies abroad and all the consular processing. And so sometimes we have to have the United States Department of State contact, talk, and process with the Department of Homeland Security and have those things jive together. Okay. What to consider is the crime in and on itself of inadmissibility or deportation. So one of the things that we should get is when you have a defendant that is not a United States citizen. Okay, so what do we look at? So what are we looking at? Inadmissibility or deportation? So the first question usually that we ask is this a crime involving moral turpitude? If so, is that applicable, eligible for the petty offense exception? So, crime of moral turpitude this is a term that is very nebulous and is kind of defined under the law, but very kind of nebulous way. Theft, fraud, larceny, burglary, misrepresentation of something to gain money. So prostitution. Those type of things are involving, and that could render an individual deportable or inadmissible. Is it a issue of good moral character? Again, good moral character is not a deportability offense in itself, but one of the things that a immigrant must show to gain an immigration benefit is that they have good moral character, and so if they cannot show good moral character, their applications might be denied. That might have a significant impact, not necessarily on just deportability or inadmissibility, but in applying to a new immigration benefit, like for example, going from a green card holder to a citizenship application. They would have some data, and we'll relate that back to inadmissibility and deportability in a second. Is it a crime of violence, an aggravated felony? Obviously, these things can actually render the individual both inadmissible and deportable. So let's talk about inadmissibility under Section 212, and that's where it's codified under Title 8, Section 212. So who is subject to the grounds of inadmissibility? So non-UN citizens who enter without inspection. So basically anybody who's nixing the party, if you were not inspected, so you didn't go through the bouncer at the front door, you will be subject to this section. Okay, and that's important because again, some crimes may render you inadmissible, some might make you deportable. So if you have been admitted to the party, then we need to figure that out first because we want to know where are you. Okay. On non-U.S. citizens seeking admission to the United States as non-immigrants or immigrants. So anybody who does go through the bouncer is going to apply this section, and the bouncer is going to tell us, okay, do you have the proper cover? Do you have the proper dress code? And it's important to know that that process for you to go to is when you have a proper visa, and a visa gives you the right to knock on the United States door, so the bouncer opens, and that will be an immigration officer, and the immigration officer will has full discretion to allow you in or not allow you in. Doesn't matter you have a visa, they can return you with a visa back to your country. So fully discretionary. Okay. All non-U.S. citizens seeking to adjust status in the United States. Um, so all citizens seeking to adjust status in the United States. So this is important. We talk about adjustment. It's basically a process in which somebody wants to change one status to the other. Typically, we see this in the context of somebody wanting to become a citizen. They're a legal permanent resident, and they believe they qualify, so they want to change their status to citizenship. Um, when you apply for that citizenship, you have to go through the bouncer again. So the way I like to see it is, once you're inside the party, you are here in the party, your conduct is good, you're a good fellow. Now you want to be part of the VIP. Okay. Well, there is another bouncer at the VIP which is going to apply this. So the VIP being citizenship. Okay. LPR, returning from a trip abroad. This is important because people can leave the country when they're legal personal resident and come back. The problem is, when they come back, you gotta go back to the bouncer again, and the bouncer is gonna apply this again. So this is again important, because if you have a crime that renders you inadmissible, but you have already been admitted, so you do something that would have, you take your jacket off. I like to think about this. You take your jacket off, but the dress code says you have to have a jacket. Well, you took your jacket off, so it's not a deportable offense. They're not going to kick you out of the party because you just took your jacket off. So, you will be okay. However, if you leave the party and you seek to come back in, the fact that they know that you are one of those who gets in and takes the jacket off are going to say, we're not going to let you back in the party. So this is important, because if somebody, then what I'm trying to get at is, if they commit a crime, counsel might tell them, look, if we plead this way or we end up this way, you're going to be okay, but just understand that you can't leave the country and come back in, because if you do that, they might find out about this and you may end up losing your rights. So that's important as to that. Inadmissibility under Section 212, criminal grounds, okay, and they are codified under Section A2. Crimes involving moral turpitude. Again, we talked about those: fraud, theft, prostitution, bad checks sometimes, if it's a lot of them. Controlled substances violations. We talk about cocaine, crack, meth, that type of stuff. If you have any kind of that violation, yeah, you're going to be inadmissible. Multiple convictions of 2 or more offenses. Even if there may not be a crime of moral turpitude, and we'll see why the definition is important. If you have 1, 2 or more of perhaps lesser offenses, they might raise to the level of crime of moral turpitude. Drug traffickers, talked about that. So not only just possession, but just trying to sell it or manufacture it. Prostitution, commercialized vice, engagement in criminal activity, and a certain immunity from prosecution. Typically, sometimes people say, I'm a senator from a different country, or I'm a high magistrate for a different country, and I can be prosecuted or something like that. That's a problem. Human trafficking grounds, of course. And really, I like to see the enumerated sections of the code, and then you have this crime involving moral turpitude. This seems to kind of be like the catch-all thing that sometimes is so nebulous under the law. There's certain exceptions to it, even though if you are in fact stuff, there's some things that we accept. If the crime was committed when the individual was under the age of 18, okay, and the crime was committed at an individual released more than 5 years before the application for admission. It's one of those exceptions, which you're 18 and the crime was released more than 5 years before the application for admission. So this is probably looking at, are you going to apply to become a United States citizen? Well, if you took your jacket off and we really do think that's a crime, then maybe you took your shirt off while you were a kid, and that was a long time ago. So okay, we might just let you slide by and let you apply, and that's the application to become public party. Petty theft of exception, maximum penalty of the crime did not exceed a year. The sentence was not greater than 6 months. So, if it's just basically a shoplifting charge, that's kind of what we're looking at. We got to look at that thing on that. The portability under section is codified from the section 233. So we have section 212 and section 233. So what makes somebody deportable? Okay, when a non-U.S. citizen admitted to the United States is found ineligible to remain. So again, we see the word admitted right here. And so you went through the bouncer and the bouncer let you in. So now we're looking at 237. So here is right here. Have you been admitted? Okay. Now we're looking at this. So once you're inside the party, okay, when can we say you gotta leave or party? Okay. You apply for a benefit, application of renewal of green card or naturalization. So you apply to become a citizen. Okay. We're gonna pass you through the deportability section, and you apply for a naturalization section also. Okay. So that's when we're gonna be looking to see if you're deportable. Okay. It's important to know that you also will be, when you leave the United States, come back, gonna go through both hurdles. Okay. Encounters with law enforcement. So anytime that you have 287G is kind of like a deputized zone under section of the code 287G. It tells us that enforcement, the law enforcement, any law enforcement is being deputized. So state police could actually ask you about your immigration status and try to see if the individual is deportable. Now, this is by state, and in Washington, Greg Warren at the time, and it doesn't seem like the government in Zilly would go against this. Sounds like in Zilly, in this way, it's just a pretty liberal that that will not enforce a 287G, that we're not really taking any deputizing from that. Idaho, I don't know what it does. I don't know if Idaho will allow their state resources to be basically immigration officers. But secure communities, like closer communities that are more closer to the border, goes along with the Fourth Amendment free zone. You are within 100 miles of the border, of any border of those communities, an individual can be stopped and be asked whether or not to see that law enforcement officer can see if section 212 or 237 apply to find whether or not the person is inadmissible or deportable. Anybody who's in ICE obviously going to go back to the deportability sections, and then Fourth Amendment restrictions, again, any place within 100 miles of the Canadian border. Anybody 100 miles from the border, where we are in Spokane, Washington, Coeur d'Alene, we are within 100 miles of the Canadian border, so therefore we are in a Fourth Amendment free zone. Okay, we talk then about deportability under Section 237 and what are the criminal grounds of inadmissibility. And again, there is other grounds, but we're just talking about for criminal attorneys, criminal law attorneys, what they need to be looking at. So Section 237A2, crimes involving moral turpitude, one within 5 years of admission from whom a sentence of 1 year or longer could be imposed. 2 or more crimes involving moral turpitude not arising from a single scheme of criminal misconduct at any time after admission. That's very important. Aggravated felonies, of course, high-speed flight from an immigration checkpoint. So make sure that clients follow the speed limit within the borders. Controlled substance exempt for a simple possession of 30 grams of marijuana. So it's important to know here it is a simple possession. It's not drug trafficking. It's not intended to deliver, intended to manufacture. We're talking about single possession, and it has to be 30 grams or less. It's sometimes very important for counsel to write the amount, because sometimes we don't see those on police reports, which is, they plead or whatever, they live down, and then the police report is not clear, and it can give big problems. It can make your client deportable, and that's a problem. Okay, You have 25 grams of, or you can stipulate or to go down to a lesser amount. Now it's important that it's a single possession, so it can be more than one. Firearm offenses, very serious national security offenses, espionage, sabotage, treason, of course, spionage, and crimes of domestic violence, stalking, child abuse, or violation of protection order. So this is important, especially when it comes to domestic violence, because we see these in families, and sometimes you got a DV violation or a violation of a protection order. That can be a problem. Okay, so it can render somebody deportable. Sometimes it's better to have an assault than to have domestic violence charge. And so if it's categorized as DV, this can be a problem, and that's very scary, especially if, for some of the family practitioners and criminal law practitioners that can bring somebody there. Refugees are special. Refugees are uh, uh, they are admitted as a refugee, so they're really not sort of like inspected. They really don't go to these admissibility grounds. Uh, they have not adjusted, so they are not LPR, so they are refugees, but they are subject to the grounds of deportability. And again, some crimes of deportability, but not admissibility. So they are inside, but we're going to be there. And one example of this is going to be DV. We just talk about DV is a ground of deportation, but it's not a ground of admissibility. So if you have a crime of DV before you come into the United States, you have a domestic violence charge in your own country, we don't care. But if you do it here, we'll kick you out. Well, that's kind of what's going to happen with them if they have a DB at this point. That would run them there outside. Refugees are non-immigrant-like students, like tourists and stuff like that. So they are non-immigrants. While those other types of non-immigrants are subject to the laws of immigrants, refugees are different. So that's kind of it. We think them as non-immigrants, so they're not really subject to inadmissibility. But we're going to make them 2 points of deportability, so we're gonna make them that. Non-immigrants inspected and admitted must show that they are not inadmissible and not deportable. So they're kind of both for non-immigrants. But refugees, they have to show they're not deportable. Good moral character. Lack of good moral character is not a ground of inadmissibility or deportation on itself, but is very important concept. And 2 steps to showing good moral character. You have to show that the applicant must prove that he is not barred by law from showing good moral character. So prostitution, alien smuggling, crimes involving moral turpitude, drug crimes, drug trafficking, habitual drunkards, confinement to a penal institution for 180 days or more, um, gambling as a primary source of income, multiple crimes with total sentence of 5 years or more, polygamy. So these things are kind of examples of not good moral character. You have to show that none of this is present. The applicant must show that she's a person of good moral character based on community standards within the following being considered. Willful failure to support dependents. So for those who owe child support, this is a problem. Okay, child support, oh man, is an issue. Extramarital affair that destroyed existing marriage. That is a out of not good moral character. Lawful acts that are not statutory but including minor convictions, arrest, etc. Fraudulent receipt of public benefits, just getting food stamps when you are not entitled, immigration violations, obviously lying in immigration application, for example, failure to register for the selective service, failure to pay income tax, so they're on probation. You can be deported for some things that won't make you inadmissible, as we've been talking through this. So domestic violence under Washington state law is not a crime of moral turpitude, so it is not a ground of inadmissibility. However, in Idaho, it could be. We don't know. I'm not an Idaho lawyer at this point, so I don't know the answer to that. If someone applying for admission but has a DV conviction, the conviction in and of itself will not be a bar to admission. Firearm violations in and of themselves are no ground of admissibility. So again, the way I see it is, if you play with fire outside of the party, we don't care. But if you play with fight inside of the party, that's a big deal. So, that kind of makes sense if you think of in those terms. Good moral character and admissibility, deportability. The inability to show good moral character will not get you deported unless that inability is derived from inadmissibility, deportability issues. Committing fraud, receive an immigration is both inadmissibility, deportability. Someone who commits fraud is barred by the law from showing good moral character, and so basically that by operational law does that. The failure to register for the selective service will not get you deported, but it can get your citizenship application denied. DOI is in Washington. DOI is on itself not a ground of inadmissibility deportability in Washington. I don't know if it is in Idaho. Again, Idaho, an Idaho attorney might be able to answer the question. But in Washington State, DOI is not. However, it can be an issue good moral character because if you are a habitual drunkard, then that does. So one DOI, probably not a big deal. Second DOI, things are getting tougher. A third DOI, so this can possibly affect the the application for new benefit at least. So if maybe counsel will say, this is your DOI, just know that that this is going to ruin your visa. So not only not leave the country, but you may have to wait 5 years or whatever for to show when you apply for citizenship or whatever that this is going to be a problem. Traffic tickets are not bars to admission or grounds of deportability. One speeding ticket, again, not a big deal, but if it just becomes excessive, that could be a problem. It's important to note here that immigration officers have wide discretion. And so it's very hard when you have that type of discretion. I mean, I think more under the law we could appeal certain things and abuse of discretion standard, but these type of things are very wide discretion. What is a conviction? For the purpose of immigration, a conviction is any consequence of a crime that puts a burden on someone's liberty. So unless one of the following is true, the charges are dropped, the case was dismissed without prejudice. For the purpose of immigration, it is a conviction. So, in short, anything that that has a fine, any kind of consequence, is in fact a conviction. And here we have a crime. I see that a lot of times people enter into stipulated orders of continuance. We're going to stipulate to continue this a whole year to see how it goes. Then come back, boom, there is a problem with that. The stipulated order of continuance is in fact a consequence in somebody's liberty and therefore is a conviction. So this could be a conviction on the ground of deportability. Okay. Inadmissibility or deportability, we did some case studies when we were there with counsel. I'm not going to go over them, but they're on the slides. I'm just going to skip here about the issues until basically the role of a defense attorney. We are aware of implications of crime on immigration. This is very important. Defense attorney does have to know this. Especially after the decision on Padilla versus Kentucky, 599 USC 136. Under this case, what we are called to do as lawyers is to be appraised of this. It's not enough to say, I don't know. It's not enough to say, I'm not an immigration attorney. Please check with an immigration attorney. It's just simply not enough. You want to have knowledge of immigration law because under that case, it was, in fact, decided that it could be ineffective assistance of counsel if that's not what we have. So that's what they did again. Padilla versus Kentucky 559. I'm sorry, USC 536. I had the wrong quote. 555 USC 356. Arguing for changes sentences that can lower the impact on criminal activity or in one's immigration. Now, I think you just need to talk to your client here, and it's important that you that you understand that some clients may not care if they get deported. That'd be a weird conclusion, but sometimes clients say, hey, life back there not as bad. I'll go back anyway. I mean, that's better than staying in a prison here. But most clients will fight to the end to be able to be here in America, not only because they have families, but they have a lot of things. So it's important that you have that. I'll talk to them. Waivers. The next possible step is if you don't have a you do have a ground of a crime and you can't not figure out a way to really get this into some of out of the inadmissibility or out of the deportability uh, um, grounds, then maybe is there a waiver? And so you need to see, well, there are certain waivers, on the grounds, time pass, rehabilitation, some not contrary to U.S. welfare or security or extreme hardship to the United States, citizen, LPR, spouse, son or daughter of a parent. So, is there a waiver available? Okay, immigration relief for victims of crime and trafficking. We do have certain other reliefs. We got the Violence Against Women Act. These are self-petitions. Typically in immigration law, you have a petitioner and a beneficiary. The petitioner usually is a United States citizen petitioning for a family member who happens to be a beneficiary. And somebody just kind of petitions for somebody else, whether it's an employer or somebody else. Well, under VAWA, women themselves can petition for themselves. And it's kind of a different type of petition in those terms, but sometimes for family practitioners, they need to know that they can probably add this. The key point here is the abuser must be a United States citizen or an LPR spouse or parent. So that can be possible. U visas, therefore victims of crime. The applicant is a victim of certain types of crime under federal, state, or local statute, has provided assistance to prosecution or investigation. That's the key. You have to provide help to prosecute somebody. The law enforcement has to do a certification to that effect. Sometimes it's easy to get those certifications. Sometimes they are not. It kind of depends on what we're dealing with. We're dealing which agency we're dealing with. Some are easier than others. Some are not. T visas for victims of trafficking. Similar to U visa, but specifically victims of trafficking. What resources can you use? Immigrant Advocates Network, Immigration Advocates, Immigration Legal Resource Center, very, very good. American Immigration Lawyers Association, AILA, Defending Immigrants, Partnership, defendingimmigrants.org, Washington Defender Association, defense.net/immigration project, United States Citizenship and Immigration Services, USCIS.gov, and Immigration and Naturalization Act. Obviously, you can also contact Catholic Charities if you want to, and Mr. Cunningham, and you can consult with myself to see if a crime have an impact on your clients and see if we can have an opinion on that. Other than that, that's what we presented. That's the end of the presentation. And again, I enjoy giving this presentation. If you are criminal counsel and you have questions as to perhaps a possible immigration consequence of one of your clients, we'll be able to counsel with you, and you can reach me at the Quiroga Law Office at 509-927-3840 or at www.quirogalawoffice.com. Quiroga is Quiroga lawoffice.com. Thank you.